State of Michigan versus John Perrone, 2500660
Ross Marchmina for the people.
Assistant Public Defender Joseph Hardy on behalf of Mr. Perrone.
For John Perrone.
Same.
We were previously together. Mr. Perrone was found guilty by jury of counts 2, 3, and 4. Today is our date for sentencing. We have a pre-sentence report. Have counsel had a chance to review that report?
Yes, Your Honor.
I reviewed the report with Mr. Perrone.
Additions, solutions, corrections to the factual content?
Nothing for the people.
No, Your Honor.
Okay. Do the people have a position on sentence today?
Yes, Your Honor. And obviously, the court sat through 2 trials in this case, heard testimony from 11 different witnesses, saw probably around 30 exhibits. You're deeply familiar with the facts of this case. There are just a few aggravating factors I would like to highlight. Obviously, this is a misdemeanor. The reason that this is a misdemeanor instead of a felony is, in my opinion, a loophole in the strangulation law. You have to put hands on neck or cover a person's, mouth, nose with strangulation. He got creative and knelt into the chest of someone who he knew had sarcoidosis in order to obstruct her breathing. So I do think that that's a significant aggravating factor here. I also would note that there was undisputed testimony and clearly corroborative testimony of him bending Angela Fox's fingers back until a bone snapped. And that's just the kind of sadistic behavior that it just shocks the conscience. I would also note that the threats that he made in the videos that the court watched about killing Angela Fox, about killing his neighbor, just terrifying. I have spoken with, I think I would also note that as the court knows, there were children there, so the whole thing. There's uncontested evidence that a child was punched in the head because he was so carelessly swinging at Angela Fox. I have spoken with Angela Fox. She's not here. My understanding is that she's likely watching the stream. She's not here. She has indicated to me that her perspective has changed a lot since she testified at the first trial. She indicated to me that pretty much all support from Mr. Perrone and from his family has been cut off. She at one point said that it's like he's already in jail. She indicated to me that she has found a job. Obviously, Mr. Perrone said in the video that all she wants is drinking and weed. She hasn't worked since becoming pregnant with his first child, but she indicated she has found a job. I'm not sure if that has started just yet. I also would note that she obviously has just been put through the ringer on this. She's been put through emotional hell in addition to the physical injuries. I don't need to walk through the court how disturbing this case was. I know that the court generally is not inclined to give jail term with people with non-assaultive priors. I also would submit this is kind of the most serious conduct that can find its way staying in this court. I wouldn't ask the court to turn this into counts that they're not. But I do believe that a significant term of jail is at the front end is appropriate in this case. The maximum penalty is 1 year in jail on the 2 1-year misdemeanors. I would ask that the court impose a jail sentence of a term of 120 days, which is 1/3 of the maximum penalty in this case. So that is the people's position on sentence.
So Mr. Perrone was not found guilty of the aggravated charge that he was charged with. We understand that he was convicted of misdemeanor domestic violence and the 2 counts of 4th-degree child abuse. I would submit that this is not something that is part of his character. It's something that which substance abuse, with the alcohol was definitely a big factor, and something that he is willing to work on. He's been taking domestic violence classes. The probation scored him as moderate or low risk. I think that is something that definitely needs to be taken into account. This is something in which he made a bad decision on this night, but he does not have an assaultive history. It's my understanding that he is the sole provider, at least according to our understanding. And I do believe that a significant jail term would impede, not just himself, but the very victims in this case by not receiving any type of financial support, which I do think needs to be taken into consideration as well. Additionally, according to the report and according to my conversations with him, he's someone that has expressed extreme remorse. I believe the specific phrase in the report was he took full responsibility for his actions and was distraught by the situation and reacted appropriately when asked how he feels about the incident. With this, I would just ask that the court follow the recommendations for a 12-month term of probation. I believe that his lack of any type of hiccups or issues while on bond speaks to his likelihood of success if he were to be sentenced to a term of probation. So we would just ask that the probation recommendations be followed.
Mr. Crum, what would you like to say today?
That day was a day that a lot of remorse that I had. I made a bad choice in what I've done. Not only did I make a bad choice with what I did with Angela Fox, but the fact that it was in the children's presence was not acceptable, and everything I did that day was unacceptable. And I apologize to all three of them.
Are you already enrolled in Veterans Intervention Programming?
I am not. I'm taking a class through CPS, Steve Hampton.
Okay, so it's not the Veterans Intervention. Okay. I do take into consideration that none of your prior convictions are assaultive, but I also take into consideration that there are child victims in this case, and whether you meant to hit your child or not, your child got hit as a result of this, and she said it more than once. You shake your head no at me, Mr. Brown. It is clear she told CPS she was hit. She told the police she was hit. It is clear that she was hit. She never said you hit her intentionally, but she said she got caught when you were trying to punch her mother. Based on that, and the fact that I don't believe that this is one night that results from substance abuse because of other things you said during the course of the investigation about financial power and control. I think this is a much more pervasive domestic situation than one night where you're drunk. So based on all that, you're placed on probation for 12 months. You are to meet with your probation agent as directed. Do not leave the state without permission. Do not commit crimes on probation. You're not to have any contact with Angela Fox without consent of the court. You're not to engage in any assaultive or threatening behavior. Do not use or possess alcohol, marijuana, or controlled substances without prescription. And submit to testing as directed by your probation agent. Pay for your tests. Complete batterers intervention programming. Maintain your employment. Do not purchase or possess firearms, ammunition, or weapons of any kind on probation. Your sentence will start with 6 days in jail with credit for 2 previously served. Based on this being first assaultive offense, I will let you report to jail Friday, September 19 at 7 p.m. But make no mistake about it. If you don't participate in the class, commit any other assaultive offenses, or violate an order of no contact, there will be lots of additional jail time. I'm not going to start you out with 120 days jail because you had a trial and therefore you didn't get to control the narrative about what the domestic violence was. So I think we have lots of domestic violence cases that are as serious as this. Your sentence is proportional to the conduct, as well as, I think, what other offenders in similar situations receive. For count 2, the fine is $200. The crime victim rights fee is $75. The state normal costs are $50, and the oversight fees are $360. That's $685 for count 2. And then I have to add an additional state minimum cost for count 3 and 4. So that's an additional $50 for each of those, making the grand total $785, which you may pay over the course of probation. While the money's part of this, it's not while you're on probation. So if you have to choose between paying for your class or paying us, pay for your class, because you need to do the class for your probation. That's the point of this. If you need to choose to pay for a drug test or pay us, you can pay for your drug test, you can pay us later. You can complete your probation still owing us money if that's a problem, as long as you're making good faith efforts. But you can't complete probation if you're skipping class and tests. Since I gave you jail, you do have the right to appeal my sentence, and of course you have the right to appeal because this was a jury case anyway. If you'd like a public defender to assist you in your appeal, you need to make an application within 14 days. Questions?
No, Your Honor.
So you're going to report out to Mason on Friday at 7 p.m. to serve your jail sentence, and of course you'll be doing your probation.
So regarding the jail sentence, I know that he's reporting, he's allowed to report on Friday. I would just formally request that he be allowed to serve out the 6 days on the weekends, just as to not jeopardize.
Well, it's 6 days credit too, so that leaves 4 left. So if he goes Friday at 7, he's probably out by Monday at dawn, if not before. So it is essentially 1 weekend.
Yeah.
Okay.
Understood. I will discuss this with him.
Okay. We're going to get you down to probation to have an appointment to sign your orders and get all your referrals to start your classes. Anything else from the lawyers?
Not for people. No, Your Honor.